So listed in the best lawyers in America, Bill Eigner is one of California's top mergers and acquisitions and financing attorney. Based in the San Diego office of Procopio, one of California's largest law firms, with offices in Irvine, Del Mar, San Diego, Las Vegas, Scottsdale, and Washington, D.C. Eigner is often called the go-to guy for M&A and emerging companies. He is also an authority on forming, utilizing, showcasing, and providing compensation for boards of advisors. He is on the board of advisors for Cross Oceans Ventured Fund, Athletiverse, Sokyahealth, Acenda and Greenbutts LLC. He is a trustee emeritus of the San Diego Police Foundation and began his career as a U.S. Supreme Court Judicial Intern. Eigner is a partner at Procopio and a graduate of Stanford University and the University of Virginia School of Law. With that, Bill?
Thank you, Don, and thank you very much. I've spoken to FENG groups before, and it's an honor to speak to the Orange County chapter. I'd like to ask how many of you are looking to raise money for your companies right now? And Don, maybe you could let me know. It's hard for me to look at the video to see who raises their hand, but basically, how many people are looking to raise money for their company right now?
I see one.
Okay, Larry, I see.
Yeah.
Okay, and then how many of your companies are looking to basically hire people right now? Okay, that's a good sign. And how many are looking for new customers? Okay, so
Everybody.
yeah, so, okay. So we, thank you. Victor's expanding my view so I can see who else on. But anyway, that's really helpful. Thank you, Victor. Okay, so that tells us that I'm going to try to tailor my talk to meet your needs. But the main thing, I'm going to be talking mostly about a board of advisors. A board of directors has many more obligations for a director. So a director has fiduciary duties, and all of you are familiar. By the way, Mark, that is a cool background with your airplane background. I love that. That's really cool. I haven't seen that one. But anyway, we're going to be talking about advisors in this talk, although it applies to directors as well, and you'll see some indications for directors. But basically, a board of advisors has no formal requirements. You don't have the fiduciary duties of an officer or director. So it's a lot easier, and therefore it's a lot easier to recruit someone, and you don't necessarily, and for you guys, so the people who are on this call are all eligible to serve as advisors for companies. So it's not just the company you're working with that may be recruiting, it may be that you're interested in serving on a board of advisors. And I'll try to tailor the talk so it goes both directions. So you'll be able to look at some of the concerns that you have, and we'll be able to see what the companies need. But a board of advisors can provide credibility, contacts, counseling, and cash. And we call those the 4 C's. Usually when you get engaged, your fiance quickly educates the men about the 4 C's. So this is a different 4 C's. So saying who you are gives credibility. So what you're trying to do is, when I was at Stanford, a friend of mine walked next door to introduce himself, and he said, "Hi, I'm Ken Lawler." And the guy said, "So what? Like, who are you?" And so what you're trying to do with credibility is you're trying to establish yourself as somebody who is surrounded by people who people respect. So if you were trying to be known as a leader in the United States, you would want your face right up here on Mount Rushmore. If you're in a particular field, consumer products, life sciences, whatever it is, you want to create your own Mount Rushmore of people in your field. And you want that reflected glory to be able to get that credibility. And you don't necessarily have to be able to afford all of those people to pay them salaries and have huge compensation packages. With boards of advisors, you can use your option plan as a currency. So that's what you're really trying for, is a halo effect. Basically, you have the credibility of the people you're with, and that adds to your credibility. And many of the people you're working with don't have, they may be first-time companies, or they're very young, and they just haven't established their credibility. And so it's hard for them to recruit talent. It's hard for them to get customers, and it's especially hard for them to raise money. So this is really important. A lot of times people will say, well, Bill, I love your idea about boards of advisors, but we're going to wait until later. And I say, no, do it now, because now is the time that you need it. If you're trying to hire someone, you're trying to get people on your board, you're trying to get salespeople, other administrators, you're going to have to give them a much larger package if you don't have credibility. So it actually saves you money to have that credibility. So basically you can land better executives at a lower price. You can land customers and raise funds with your credibility enhanced. And people who look at a company look at the team's track record. So if you have a young company or a company that's not quite advanced, then you need people who have been there and done that. And if you can't afford to buy the talent, you can rent it using a board of advisors. So boards of advisors bring contacts. They might be able to help you find employees, help you find customers, help you find money. And they provide the counseling. When you have a small company, as you guys know, if you make 2 or 3 major mistakes, you're out of business. And having experienced directors and advisors who have been there and done that can help you avoid things. You might say, oh, this market looks really great, I'm going there. And they may have experience and steer you clear of a cliff that could have killed your company. And then cash. This is, for those raising cash, this is most important, is to have this, the board of advisors can help you raise the money. So the ideal type of advisor, if you're raising cash, is somebody who is in your field, who has built a company using investors, has made money for the investors, sold the company to someone who's likely to buy your company, worked for that company, has good ties to that company, and enough credibility to make an introduction of your company to theirs. Now, it's hard to find someone with all of those qualities. And so sometimes you have to piece it together. You might have one person with some of those qualities, someone else with something else. And so it's a real art to put these things together. But ideally, I mean, imagine if you're in a particular type of company, let's say that you're doing some kind of wireless chip, and you have somebody who was an early employee of Qualcomm, and they're still on good terms with Qualcomm, and your goal is to sell to Qualcomm, either sell your products or sell your company to Qualcomm. So if somebody that they know is on your board of advisors and they trust that person, and she says, hey guys, I'm working with this company, and remember when we acquired this other company? Well, these guys are even better. And I really think you need to take a look at them. And when that person says that to Qualcomm, they're more likely to buy you. They're more likely to give you a higher price. They're more likely to partner with you, whatever it is you're trying to do. So what you're trying to do is find people who are connected and will help bring in what you need. So, but there are different advisors for different roles. Some are there for marquee value. If somebody happens to be, if Bill Gates is available to be on a board of advisors, he might not even return your calls. But if he's willing to list himself on your website, you're happy about that. The marquee value can be really helpful. On the other hand, there are people that you really need for steering you from week to week, where you might call and say, should I do this? Should I do that? So there are different people for different roles, but you don't want to over ask with an advisor. How many of you have ever taken a life-saving course, like in the waterfront? Okay, I see Don has, Bill, Ray, okay, and Dave. And Rick too? Okay, well, anyway, one of the things that's really surprising to me when I took a life-saving course at Camp Tippecanoe in Ohio was the waterfront coordinator. He said, okay, I'm drowning, come here and save me. And you're, like a 12-year-old kid, you jump in and this big guy's there and you try to save him and he grabs you and takes you down and you're scared witless. And you have to fight him to save him. And that's the feeling that a lot of advisors get, is because founders of companies sometimes get so desperate that they grab on to their advisor and make the advisor do too much. And so these advisors really get reticent to get involved. And what happens is you find an advisor and you want them to advise you what to do. You want them to help recruit, and then you want them to invest. And you get so enthusiastic about it that you drive them away. So what I counsel my clients to do when they're doing a board of advisors is make it real easy for someone to serve on your board of advisors. Limit how much time you're going to take of theirs. Don't ask them for money. Don't ever ask them for money. If you do your job right, they'll want to invest. And that's a really hard thing. You're a drowning person and you're grasping on for help, but you have to resist. And the advisor will want to help a lot more if you really just showcase the company. So that also calls into question whether you should have big meetings of advisors. I personally don't. And I'll tell you why. I had a client who was doing a telecom company based in Rancho Santa Fe, a real nice suburb of San Diego. And he had a wine and cheese thing at the inn at Rancho Santa Fe raising money. And he invited his neighbors and friends, and they all went there and had nice wine and cheese in a nice place. And he gave a talk about his company. And then his next door neighbor said, I worked at AT&T for 15 years. AT&T will never invest in this company. And here's one guy saying one thing, and he might have been right, might have been wrong, but there were 20 people there and they all just finished their wine, cheese, and left. Not a single person invested. Because in a group setting, one person can screw it up for everyone. And you are trying to raise money from your advisors, but you're not trying to make it a hard sell. So if you are meeting with your advisors in a group, that can happen. Basically, one person finds one fault and the rest just gets soured on the company. So for that reason, and for the fact that a lot of advisors like to hear themselves talk. And so they don't really appreciate hearing other advisors talk. So for a number of reasons, I just have my founders meet one-on-one with the advisors, not in a group. Some companies at some point might have group meetings, or they might have a social, but they shouldn't have remarks or discussions about the company unless they can control the situation. Otherwise, this Inn at Rancho Santa Fe nightmare can come up, and I've never forgotten that story. So ideal board member characteristics. It's hard to find all of these things. By the way, if you'll let Dawn know, or I could send it to Dawn, or any one of you, you're welcome to email me and I'll send you these slides. So you don't have to worry if you're not catching one of them.
We've got a LinkedIn group we'll post them on. Okay,
great. This again kind of goes over the ideal situation, but it's hard to get the perfect person. Now, people will say, well, how many advisors should I have? And my answer is, well, it depends on what you're going to need, and it depends on your bandwidth. And it also depends on the personality of the advisors. Some advisors really demand a lot of like you have to get back to them. They hold you accountable, and others just are there when you need them. So, but typically it's 2 or 3 for a single founder. If you have more people, and then you can expand it as your needs grow. And it's also important to have term limits, which we'll talk about later. But a company's lawyer can be a great connection. LinkedIn can be very helpful in finding advisors, but I would not contact somebody through LinkedIn that you don't know. But LinkedIn might remind you of someone you know. Like, let's say that you're trying to go to Becton Dickinson, Becton Dickinson or somebody like that, and you're trying to say, who do I know there? And LinkedIn is helpful for that, but I wouldn't just say, I want to meet someone here and I'm going to contact them. But industry organizations are good, and FENG is great. I mean, just tapping people within FENG can really help your various companies. And here are some other resources, and you'll see those in the slides. What I suggest is you have to be really careful, because if you get the wrong advisor, it can put a taint on your company. So ideally, you would do pre-employment type screenings. That's hard to do. It's hard to do, but if you can, try to do that. If not, just make sure that you're not judging just by appearance. So you really should do some due diligence before you recommend someone or bring someone on. And if you really ask questions of these potential advisors, my view is that a good person doesn't mind being asked the questions, and you shouldn't care what a bad person thinks. So don't be shy. It's your reputation on the line, your company's reputation, and so you owe it to everybody. So let's talk about term limitations. So your board of advisors at the beginning is not going to be the same board of advisors later at different inflection points in your company. So you bring people on, and your needs change. And so what I do is I invite people on for a calendar year. Now it's already November, so I would just say, through the end of 2023. So I would say, Larry, would you be on my board of advisors through the end of 2023? And that way, if Larry is a really great board of advisor member, then I would reappoint him. But if he doesn't return the calls, if my needs change, like let's say Larry had a particular connection that I needed. And it turns out that that connection doesn't go anywhere, then I might just say, well, thanks, Larry, for serving. It's now December 31st, 2023. And, we're not going to, we're appointing one for 2024. You won't be on it, but you're still going to have your options. We appreciate all you've done. And here's a Ruth's Chris gift certificate. And here's a plaque for having served on the company board. And we call that plaque and sack. So, so your board of advisors is going to change as your needs change. And there's nothing wrong with that, but you have to treat people with respect. And that's how to do it, because otherwise you have to have a frank discussion with people and fire them from a board. And that's horrible. And they feel unappreciated and humiliated because people will say, hey, Rick, I saw that you're on this board. And then later, oh, you're not on that board? What happened? And then Rick's got to explain. But if Rick can say, well, I served, on the 2023 board and, my term expired. No one's going to say, did you get reappointed or why didn't you get reappointed? But if you serve the natural course of it, then that's fine. And you don't lose friends from the company standpoint. You still have Rick looking for opportunities because he still has options. So let's talk about options. And fortunately, I'm talking to the right group because you guys administer option plans and what's going on with that. But typically, we have 10 to 15% of the outstanding shares reserved for an equity incentive plan. And when I talk about equity incentive plan or stock option plan, I'm using them interchangeably. It's not precisely the same thing, but it's close. And then again, we appoint directors and advisors for defined terms. So usually what I do is invite someone on for a 1-year term, but their options vest over 2 years. And so that it gives them an incentive to do a good job to try to get all of their options vested. And let's talk about some of the rules of thumb for issuing options to advisors and directors. But keep in mind that these vary depending on how successful the company is, the founder's track record, and a lot of other things. If they're funded or not, what are their chances of funding? So we'll skip this slide because this group knows what stock options are. But here's a rule of thumb. So for an independent director not representing a venture capitalist, typically receives 0.5%. That's about right. An advisor typically receives 0.25% to 1%. These are just rules of thumb, and it depends on the company. Now this is, now a number of you are going to be advisors for companies. And so these are some things that really matter to you. Your vesting. So your vesting should be monthly over the term, not with a cliff. A lot of times for employees, there's a 1-year cliff. But if you're an advisor to a company receiving only options, you do not want a cliff. It's not fair to you because you're providing services from minute 1. You're not getting a salary for that. And so there shouldn't be a cliff. They shouldn't be able to terminate you in month 10 and you leave without any compensation whatsoever. So 2 year vesting, no cliff, and vesting should accelerate upon a change of control. Keep in mind that that's not automatic. So that it's important to negotiate for that. And here's what's really important for you if you decide to be an advisor. The post-termination option exercise period should be long. Typically for an employee under an incentive stock option, you have to exercise within 30 to 90 days. But if you're an advisor, there's no reason that you should be tied to the same strictures. So for you, 30 to 90 days would be ridiculous for a privately held company, because that means you've worked for free if you don't exercise. You basically, within 30 to 90 days of your termination, you have to write a check to the company to exercise your options. And you don't know if the company will ever be sold, if they'll have any kind of exit. So for you, you need a long post-termination option exercise period. It's the only way to fly. Otherwise, you're working for free because your term of service may end. You have 30 to 90 days. You have no idea if the company is going to succeed. So you walk away and you don't exercise. And then you later see them on the cover of the Orange County Business Journal or Fortune magazine. And you're thinking, I was such an idiot for not exercising, but you weren't an idiot. You can't see the future. You have to, it's only reasonable for you to have a longer window to be able to see. So when I serve on boards of advisors, I ask for a 7-year exercise period. And that sounds extreme. And the lawyers for companies resist that because they're so, in their minds, they're just thinking, well, our option plan calls for 30 to 90 days. I can't get my head around this, but you have to explain why this is important. And the same thing when you're at the company, it's not that costly for the company to treat its advisors correctly. Also, when you're taking care of trying to publicize an advisor's connection to the company, it's really important to make sure the advisor signs off on anything you do. So make sure that they approve their bio, make sure they approve where it's listed. If they're not going to let you put it in your pitch deck, then you have to consider if you're going to bring them on in the first place. But they should have the right to say if they're in or out in particular places on your website. You should put it on the website, in the pitch deck, wherever you can. Also keep in mind that let's say that Victoria is on my board of advisors and I feature Victoria in a press release and put her photo in and everything. Her friends and colleagues are going to say, Victoria, how's Eigner Corporation going? How do you like working there? Working with them. And so she'll be connected to it, whether she wants to or not. And so she'll have a vested interest in making sure we succeed because people start to connect her with the company. And it makes them identify with it and work harder. And plus they just appreciate the recognition. So make sure to really feature your advisors and treat them well, but make sure that you agree ahead of time how they're going to be featured. And I once found myself listed as an advisor to a company from China that I had no idea who they were. So you have to be careful that people don't overuse these things. But the reason they did that is they realized that it's really valuable to gain credibility by having a board of advisors. It's just they skipped a few steps and didn't ask. But anyway, it does illustrate how important it can be for a company. And then now a lot of times people will say, well, this is, like Don Nesbitt is just the greatest guy in the world. I want to put him on my board of directors. Well, that's fine if they know Don. But if they don't know Don, or it could be Ray or someone else, they need to try them out first as an advisor. Because what people don't realize is founders will start out with 100% of the company and then 80% and whatever, and they don't understand that at some point they're going to be below 50% and they might even lose their power sooner. And the board can hire and fire them and set their salaries and bonus. So you really need to check out your advisor. If you're the CEO of a company, you need to check out your advisors first before you put them on your board of directors. It's just a survival instinct. So now I'd like to get your experiences, because all of you have either been advisors to companies or have had opportunities. I'd like to hear which of these things I've said make sense to you, which don't, and try to learn from you, and also answer any questions.
Bill, I've got a question. You seem to be using board of directors and board of advisor interchangeably. Is that on purpose? Is there a difference between the two?
Well, I mean, for issuing options and choosing people, it's pretty similar. A lot of times the directors are imposed upon you by investors, but for advisors, I would not put anybody, I'd also use the same principles. So if you're not forced to put a director on your board, again, I would use the term limits. So a lot of the same principles for options, term limits, things like that apply to both. A lot of times people are interested in both, and that's why the talk kind of mixes it up. But I think in the future, I'm going to just call it Board of Advisors talk, at least, for depending on the group. Some groups want directors, some want advisors, and then some want both.
Yeah.
But yeah, I kind of masked it up there, Don. So, but
Bill?
Yes.
Bill, can you talk a little bit about the legal pitfalls of being on a board of directors, and talk a little bit about D&O insurance?
Yeah. So the biggest thing I can tell you about being on the board of directors is don't go on for any company that's raising money, especially if they're raising money, without D&O insurance. And there are some really scary things about D&O insurance that I didn't realize, and I've learned the hard way over time. One of the scary things is that they're not, you have to make sure that you're signing up for the right kind of policy and you have a great insurance broker, because what can happen, Rick, is that sometimes it comes time for renewal and your company is running on fumes and you have no money in the bank and you're trying to close an offering, and they're basically saying, can we see your bank statements? And you're saying, we have no money. And they're saying, well, we're not going to renew you. And you're saying, but we're raising money. And they're saying, well, sorry, you don't have it. Come back after you raise the money. And as a director, you're thinking, do I want a company raising 25 million with me on the board, and if the company doesn't succeed or they raise some of it and squander it, whatever, do I want that liability? And so it's very dangerous as a director. So make sure that you can renew your D&O policy and renew it early and often before you run out of money. It's kind of, you would think that if you pay the premium, there should be no problem, but sometimes there's a problem. And that was something I learned the hard way.
So can you give us any nightmare scenarios of like where somebody on the board of directors was held personally liable for something that the company did?
What I've seen over the years have been close calls. And a lot of need for roll aids or other kinds of antacid, especially with when you're close to insolvent. So I've seen threatened litigation with directors. The directors get sued over a lot of times they get sued over unduly diluting people and things like that. If the company's losing money or going bankrupt, I see less of the actual lawsuit happening. But I've had to talk directors off the ledge who are ready to jump because it's been so stressful for them. So yeah, you could get sued for breach of your fiduciary duty. There are all kinds of things that happen, and people look for deep pockets, but I see it all the time. But when I start to recollect over 20 years of practicing, I don't remember somebody actually like becoming bankrupt personally over it. But in their minds, they were as close to death as they could get, and it scared the crap out of them. Good question, though.
Thanks.
Bill, I stepped in with a startup company in Connecticut that had already done a number of things that were suboptimal, and having you shared on this presentation is helpful because they're having issues about, mostly board of advisors, people who they name to the board of advisors, no term limits, people who they never heard from again. So they're going to need to bite the bullet and drop some people and establish term limits, which, you go through it once and then I love that suggestion. I don't know why I didn't think of it myself, but that's why I'm on presentations like this. And, the board, they had a problem with the board that has been kind of rectified. And I say kind of only because there are some share ownership issues that have to be resolved. But, that's the other thing is the founder, the lead person who's now the CEO, he's a very generous guy and he likes to take care of people. And unfortunately, he launched the company with 2 other people having a third of the ownership. And then one of them was just useless, was beyond useless, was negatively impacting the company. And, it was easy to fire him as an employee. I mean, the C-level, we're not getting paid yet because we haven't closed our funding, but it was easy to get rid of him that way. It was easy to vote him off the board. But getting his shares back is not so easy. So.
Yeah, so what the good thing that you have going for you is it's November, it's almost December. So you can use even if you didn't invite people on with a term limit expectation, you have the excuse of the new year now. So you can hopefully avoid losing friends by saying, okay, hey, we're now configuring the 2023 Board of Advisors and the 2023 Board of Directors, and use that as an excuse for who's staying and who's leaving. And no one gets fired. It's like the kids' soccer team. Everyone gets a trophy. It's the way we have to do it. Because we don't want anyone bad mouthing the company, and so yeah, that's a good way. Now with regard to it's hard to pry stock back from people, and that's really a nasty business. Sometimes what you do is you just naturally issue more stock to the performers and eventually dilute down the people who got their shares in an ill-advised time by the founder.
Yes, that's
ideally you would ask them to put some of their stock back, but that's easier said than done. I can just sit here in my chair and tell you to do that, and then you have to deal with the people. But yeah, I would consider, you may have to create an Italian lira cap table where everyone has 10 million shares, but at some point you'll be able to dilute down the people that unfairly receive too many shares.
Well, we're already
Yes, oh.
looking at a reverse stock split to keep from going the lira route, but
Okay,
just to save us money in the state of Delaware.
yeah, that's right. You have to, that's what I was going to say. You have to keep your par value down. And there are other ways to do it. Yeah, the Delaware thing, that is the most horrible. I mean, people talk about how great Delaware is, but Delaware has given too many of my clients heart attacks. Like, Bill, you said to incorporate in Delaware. I just got a tax bill for $32,000. What kind of an ass are you?
Yeah, it's
And then
not
I
a,
say, hey, there are 3 ways to compute it. Please take a look there. Oh, here's a website where you can compute it. Oh, okay. All right. Well, maybe you're not quite the ass I thought. Sorry.
you know, a little off the subject, but maybe people know this, and I feel like I should know this, and I just don't know. If you do a reverse stock split, does that also affect your authorized shares?
Yeah.
You do a
Well,
1 for 10, and you have 1 million outstanding. Do you now have 100,000 outstanding? I mean, not outstanding, but authorized. Does it
it
affect? the
depends on
authorized?
what you put in your certificate of incorporation, your amended and restated certificate. So
Okay.
you need to, they'll kick it if you haven't been specific enough.
I mean, I
Yes.
suppose the other option is to do the reverse split and then reauthorize a bigger share number and issue that back to the state. But yeah, the tax issues, we got to keep an eye on that. You know, we're already way too high in our share count.
But if
30% of
let's
the company
say-
was 300,000 shares, and that's like, why didn't you just make it like 30 shares or 300? You know.
Well, you can still have 10 million authorized shares and so forth and not pay a ton of franchise tax in Delaware, but you have to have the right par value.
I see.
And there is, so you want it as low as possible, but if you go too low, then they'll count it as though you don't have par value and you'll get hit again. I forget how many decimal I have in my contacts list. I have it listed for how many zeros you can go and
Are
still,
allowed.
yeah.
I'll
And
do some
they
research on
changed
that.
it. They changed it several years ago, but you try to go as low as you can without going too low, or else you get hit with that tax. So you're correct to be careful around that minefield.
We'll figure it out. Appreciate your input. And, you know, there's a lot of valuable things in this presentation that's going to help me work with the CEO to reformulate and fix some of the past sins. I don't-
You're
any other
welcome.
sins, maybe one of them is a mortal sin. The rest are kind of venial. So what we can do.
I think we've all seen these situations, and you know, they all go in the category of it seemed a good idea at the time.
For sure. Well, and I'll just add, and now potential investors are saying, well, when you figure out this stock thing, come and talk to me, because
Yeah,
they don't
you
want
want
to
it
put money
cleaned up.
into a mess, and I don't blame them.
Yeah, you don't want a rat's nest there. You want it all cleaned up. And that gives you an excuse too, to ask for help from some of the people who receive too much or whatever. You basically say, hey, we're raising funds, and we talked to one VC and she was really not impressed with our cap table. And so we need to clean it up before we talk to more.
So then we offer them par value to give their shares back, which for us, par value is like 1/10 of a penny.
Okay.
So we're already pushing the zeros, but anyway. Appreciate Appreciate all your guidance here.
You're welcome. You're welcome. Anybody else with any pressing issues that you're dealing with right now? Okay. Any other questions?
I'll have one. So I'm the company I'm CFO for is family-owned subchapter S, but we've got 2 directors looking for a third, possibly. They used to have 3, and one for medical reasons dropped off, subsequently passed. Should the existing 2 board members participate in that search? I know you had a couple slides there about resources for searching for new members. I know there's some discussion about going back and adding a third. It's been a few years with only 2. So I was wondering how the process might unfold.
That's a good question, Dave. I would let them participate because they're probably significant stockholders of the company and could remove them anyway at one point or another. So I would let them participate and maybe give them 2 or 3 people. But again, I would, if I'm either one of them, I would want it to be someone I knew really well, or I would want to maybe bring the person on as an advisor for a few months, 6 months, and then promote them to the board. And then finally, I would just invite them for a 1-year term and see how it works out.
Okay, interesting. Yeah,
But,
where it says subchapter S, so the board members are paid. They don't have any stock. It's all family-owned stock. So.
So are the board members family members?
No, they're paid. They're paid. The owners are family, so it's a subchapter S, family-owned. So the only shareholders in the company are family, but these are outside directors, non-family, non-owner, but they're paid a stipend.
How interesting. Okay, yeah, that's very interesting. In that case, I would definitely involve them in looking for the third. If I'm the family, though, I'd worry. I wouldn't want these directors to be too cushy and
right.
and saying, yeah, we just did a survey of director compensation, and here's what it should be, and it keeps going up.
Right.
I would open it to the family as well as the
Right.
directors, but again, I would still, in that case, you might. Who are the officers of the company, though?
The president's one of the owners. The secretary is an owner, separate owner. I'm the CFO, so I'm technically an officer. And then the VP is the son of the president. He's going to be the designated president when the current president steps down. So shares by the way that the company structured stay within bloodline of the family. That's how they set it up.
Well, I would be tempted to do a Dick Cheney type of executive search and name Dave Quimby to the board.
Yeah, that'd be a little slick, I think.
But actually, it might not be bad because I'm sure you have good suggestions for the company that they don't listen to.
Generally, they do. So I
good.
think for now, it'd be a kind of a conflict because at the board meetings, I'm the main presenter.
Okay. All right.
Well, I'd be presenting to myself and the other 2, right?
I wouldn't necessarily see it as any more of a conflict than they have, but anyway, I'd be, whoever you bring on, if you're going to make a mistake, I mean, there are going to be mistakes made at one point or another, and and so you want to limit your mistakes, and so therefore trying people out before they're a director is best, and then having a term limit limits you from really screwing things up, and you can always remove them sooner. In this case, if they just don't work out, you could even bring someone on for a provisional period, like a 3-month term. Like you can say, hey, we have we need someone to kind of break ties and we have a provisional time of 3
Mhm.
months and then
Okay.
see how they do.
Got it. Thank you.
You're welcome.
I think we have time for one more, Don.
Yeah.
Hey, Bill, this is Jean Latu. I sit on the board of directors of an ESOP.
Oh, wow. Okay.
Yeah, interesting. It's a small company, 18 million in revenue.
Mhm.
We have 3 outside directors, including the chairman. And we have 2 internal directors and contemplating adding a 3rd and a 4th. For that size company, how many directors is ideal?
I think 3 to 5. And it again, you just don't want people who read their board packages the day of, during the meeting. So it really depends upon how actively engaged they are. And, yeah, 3 to 5, I would say. 3 is easier to really collaborate with. 5 might make people behave more professionally.
No, that's true.
So at 3, you kind of like, people want to just have their board meeting on a phone call or just through or make decisions through email rather than have a formal meeting and, all in favor say aye. With 5, you would be more formal. But 5 means more compensation to outsiders. So it's kind of you have to, if you have the right people, 5 could be great. If you have the wrong people, 5 is not good. So.
And should you always have an odd number?
You ideally, but it's not, some people they will go out of their way to bring someone in to have an odd number. To me, I'd rather have an even number than have the wrong person as an odd number.
Okay.
So follow those same rules of trying people out before putting them on the board if you can.
Yeah.
And you can also have people attend as provisional board members or observers for maybe 2 or 3 months. Most of the people don't care if they're officially board members yet, if they're getting some kind of compensation, either options or payment. So that's the main thing that the people care about. So you can protect the company by not giving them full power until you're sure of them.
Good thought. And you're right, we can always have them observe if we feel there's more internal folks that need to know what the board is all about.
Yeah, and you could just ask for their comment on things. They see all the board package and so forth.
Right.
And then try them out.
Yeah.
Kind of like date before get married.
Exactly. All right. Thank you.
You're welcome.